Uh, there were two presidents in recent history who actually reduced the government spending as a percentage of GDP, and that was President Clinton and President Reagan. So I say that in a bipartisan way, one on each side. A part of that was a growing economy, and I think that's going to be the key to us facing our national debt and our deficit. So I want to applaud Chairman Gensler, your statement today, and I think, if I heard it correctly, it's that all end users would be exempt from CFTC clearing and margin requirements
The way
on
that
the over-the-counter swaps.
consistent how Congress exempted the non-financial end users from clearing, as we take up these rules at the CFTC, which we hope to in the near term, that the same end users, these 2H7 is the provision in the statute, would not have any margin requirements. It's really consistent with what Congress did when the clearing requirement. The transactions financial company to financial company, consistent with what Congress did. Might be, again, we're still sorting through these proposals to put them forward to the public and get comment.
We think I know members on the majority feel it's critically important that we don't impose margin requirements or clearing requirements on end users. And by end users, you said non-financial companies. These that do not, they hedge risk as a part of their inherent business.
That's correct. Hedging is a really important thing. Tens of thousands of commercial end users use these products, use them successfully, did before 2008, and need to for our economy to prosper. Dodd-Frank, at its core, though, promotes transparent, open, and competitive markets. And markets that are transparent and competitive get the lowest pricing. I believe Dodd-Frank, at its core, will lower costs to these commercial end users because of the transparency and competitiveness, and also because they'll be less prone to risk. I mean, the American public did have to stand behind that $700 billion in the TARP. So it's a balancing that actually Congress put forward.
Of course, the $700 billion, none of that was a result of commercial, non-financial end users.
But it did, at its core, have a risk from the unregulated swaps marketplace, particularly credit default swaps, and we all know the story of AIG.
I appreciate you. And do you need the cooperation of Congress? Do we need legislation to clarify that these over-the-counter swaps will not be required to have margin requirements or clearing?
We at the CFTC believe that the Act is well written, and it gives us sufficient authority to ensure that such margin requirements on the swap dealers does not cover the non-financial end users. That authority is there for us to move forward. Of course, it will be subject to notice and comment and public comment.
Governor Carrillo, you looked at that provision. Do you agree?
Mr. Chairman, what we have done is to read the statute as it's written. The statute as it's written tells us that each registered swap dealer and major swap participant for which there is a prudential regulator has to meet minimum capital and minimum initial and variation margin requirements. How that applies broadly, and there's obviously no exception provided for any class of counterparty. However, the statute goes on to say that these standards shall be risk-based. And bringing to bear the risk-based or systemic risk-based perspective, which we've tried to bring to our activities on Title VII generally, what we are thinking in terms of is a risk-based approach to margin requirements, which would recognize that for end users generally, there is much less risk associated with derivatives transactions. So what, in essence, we will do will be to create, if this approach turns out to be the one we adopt, and it's the one that's being worked on internally now, what we'd do would be to create these thresholds within which or under which margins would not be required. And precisely because end users in general present substantially less systemic risk, and in many cases no systemic risk, those margin requirements for end users, the thresholds for end users would be substantially higher than those for financial market participants.
All right, thank you. Let me very briefly, I think the proper sequencing of your rules needs to have a definition of swap and commercial risk prior to some of your other definitions. Are you aware that that you're going to need to define those terms fairly soon?
The statute defines many terms. We jointly with the SEC put out proposals in December on swap dealer, major swap participant, and the like. The comment period actually closes February 22nd, and what we encourage the public to do, and we've posted this on our website, is if you have comments on any of our other proposals at the CFTC, even if the comment period closed, please include those comments in these definition comments so that we can consider them. We do have discretion even after a comment period to close to get those comments to the right file, to the right team. I know as a commissioner we'll read them.
But the definition of swap and commercial risk, your other definitions are going to depend on that definition.
The definition of commercial risk also we put out in December,
okay.
And that's open through this same period of February 22nd, and we look forward to hearing broadly from the public whether we got that right, consistent with what Congress did.
I would just add, I think we all share your concern that we get the sequencing right so that particularly those who have to comment understand the full scope of the potential implications of all the rules on them, whether or not they're going to be determined to be a dealer or a major swap participant or some other kind of participant in the marketplace. So we have gotten a lot of that done. The narrow, not so narrow, but important issues of swap, mixed swap, security-based swap there are basic statutory definitions, but obviously there's more work for us to do there, and we're very committed to getting those out quickly.
Thank you. Thank you. Ranking Member Bryant.